Well, the jury is starting to deliberate in the Samsung versus Apple trial. What were the instructions they received? We'll tell you after the break. Hey, Jessica.
Hey, Simon.
Good to see you.
You too.
Jeff, shot's a bit pixelated. Welcome back to Digits here at WSJ Live. I'm Simon Constable. Well, the jury started deliberating in the Apple versus Samsung case out in San Jose, California. Question is, what were the instructions that jury received? Well, we got the one and only Jessica Vascellaro joining us now from Washington, D.C. Sorry, not from Washington, from San Francisco. You were in San Jose yesterday. We spoke with you. Tell us about this.
So the jury started at 9 a.m. this morning, deliberating on this case, and we have no guess of how long it will take them. But yesterday they were actually read over the course of well north of an hour instructions, which is how they're supposed to apply the law to all this evidence they've seen over the past more than 3 weeks. So these instructions range from: this is a patent. This is how you would find that a patent is invalid. Here's what you must consider if trade dress is violated. So it's a real breakdown, more than 100 pages of instructions, about 84 in total. And that's what they're going to be using to check against the evidence to try to reach a verdict.
Now, I do love one of the quotes that you have in your post on Digits from the judge. She says, "I need everyone to stay conscious during the reading of the instructions, including myself." So obviously she knows that this is kind of long and arduous, right?
Yep. And so yesterday when she said that before she read them, she also told everyone that she was going to request everyone stand up every once in a while just to keep the blood flowing. And that definitely happened. So now it's in the jury's hands. It's probably also interesting to note that the instructions themselves were very controversial. So Apple and Samsung were both pushing until the last minute to change different wording in the instructions. The idea there that if you sort of suggest to the jurors certain things or you describe their burden of proof a little bit differently, they might reach a different answer. So that was a really interesting to see, and probably something that will come up again when this is undoubtedly appealed. Both sides, could use disputes they had or issues they had with the jury instructions to try and invalidate the outcome if they wanted to. Now,
you say in your post on Digits, in the order she wanted to drop. She would drop any mention of what's known an adverse inference. Can you explain what that is and what the decision she made was, because it's not obvious?
Sure. So based on what an earlier judge had ruled in the case, the jury was going to hear in the instructions that Samsung did not live up to its burden to preserve evidence. So basically, an earlier judge had decided there was evidence that Samsung, not that they had willfully destroyed evidence, but they just hadn't necessarily kept everything they should have. Excuse me. So Judge Koh actually ruled that Apple hadn't either. And so she wanted to ding both parties in the jury instructions, excuse me, and have that clause read to the jury for both sides. But she gave him a choice. She said, do you both want it or do you neither want it? And both sides said, we'd rather the jury didn't get that notice about us, either of us, so she struck it and it wasn't read. But that's been a really controversial issue too, because obviously telling the jurors that one side didn't live up to their evidence obligations could definitely sway their opinion.
I'm sure that would. I mean, that sounds pretty inflammatory. Just, I mean, even without having followed the trial as closely as you had. There's a great quote, another great quote from this judge. She's like a quote machine. She says, quote, the court presumes that as officers of the court, the attorneys will comply with all pre-trial and trial rulings in this case. Now that seems obvious, but it also sounds like she's talking to a room full of 5-year-olds.
I think she maybe in her mind thinks she is at some points. I mean, she's been Apple and Samsung probably have the best patent lawyers on the planet, and they're going at each other, and they're fighting tooth and nail on every last point. And she's clearly made it clear time and time again that she won't stand for, you know, these disputes over everything and sort of playing games. So that quote was in response to actually a request from Apple that the judge order Samsung not to mention excluded evidence in their closing argument, which you would think, why would Samsung mention excluded evidence in their closing argument? But there had been a couple issues around that, and I think Apple just maybe wanted to draw attention to them, so they requested that order, which she, in no uncertain terms, shot down.
Yeah, she's pretty forceful and pretty blunt. Thank you very much, Jessica Vascellaro. Thank you there. Get continuing coverage of this on WSJ.com, including the verdict when that comes out.